Super. So thank you for everyone for joining us. Today we're here with several panelists to discuss pursuing justice for Russia's war crimes in Ukraine, recent developments on the legal front. And in fact, as you'll see in a few seconds, you'll hear in a few seconds, I think one of the questions this panel in particular will be thinking about are questions on the legal front and questions caused by the legal front and the extent to which the legal front is the front. And so that's part of our conversation today. Let me just do a very quick round of introductions. It's a large panel. And again, so thank you for everybody for being in the audience. It's a large group of you. I'm Ron Levi. I'm here at the University of Toronto in the Munk School of Global Affairs and Public Policy, as well as in the Department of Sociology. And I teach on atrocities as well as on social science of law. We're joined today by 5 panelists, some of whom are already close friends, some of whom know the school well, and some of whom have been on prior panels discussing this very topic. And so a bit of a check-in time for everybody. The first is Gabrielle Schlevikaita, who is an assistant professor in empirical and normative studies at the Free University of Amsterdam. And Gabrielle, who has visited at the University of Toronto in the Faculty of Law just a few months ago, does work that is both empirical in terms of studying how international criminal justice operates, as well as policy and practice oriented. She herself has been an analyst at the International Criminal Court and worked with the independent expert review of the International Criminal Court. So she brings that combination to us. Monica Eppinger is associate professor and co-director of the Center for International and Comparative Law at St. Louis University. She has published extensively on issues relating to war crimes, and the American Society of Comparative Law has selected her article on private property in Ukraine as one of the major papers discussed at Yale Law School. She has policymaking experience in Ukraine, Eastern Europe, and elsewhere, and has received the State Department's highest civilian honor of the Individual Superior Honor Award in 1999. We're also joined by Ilona Khmeleva, who has a PhD in law, specializing in international law from the University of Kyiv. She coordinates the project on Ukraine in Europe and is an expert in the field of international law as well as international relations. And she as well is with us at the University of Toronto this year as a non-residential fellow in this very center. So welcome to the group, Ilona. We're joined by MP Alexander Merezhko. Alexander is a doctor of law and a professor and chairman of the Committee on Foreign Policy and Interparliamentary Cooperation, Ukraine. And so we have direct and immediate experience coming from Alexander. And then finally, and I name him last, but he'll be beginning our conversation today, is Professor Afonso Seixas Nunes, who has recently joined the University of St. Louis School of Law. He himself holds a PhD from the University of Essex, where he worked on issues of drones and autonomous weapon systems under international and humanitarian law. He's been at Blavatnik in Oxford. He was a junior research fellow at Campion Hall at Oxford, and is in addition to this an ordained Jesuit priest, when he was ordained in 2010. So thank you to everybody for joining us. I know that's a lot of introduction and a lot of throat clearing. But I think, we've been brought here today to discuss, in a way, 3 pieces, right? The first is, what is the legal front, if we think of it in that way, if we just look at the title. The second is to consider recent developments on the legal front. And so there's a contemporaneity to this, or sort of what's happening right now. And then the third, which is sort of how I want to just set up the beginning of the conversation, is to think about, is this on the legal front, or is this the effects of or caused by or avoiding the legal front? And so I'll put out into the environment just a couple of questions. But again, these can be questions that sit in the background for panelists, or you can take them up in your conversation, or they may spur questions from the audience. The first is in fact, very of the moment, is what happened in Poland yesterday. And with that, conversations around NATO's action or inaction or requirement for action. And so there's a question there about the legal front when violence happens outside of both Russia and Ukraine, and the extent to which NATO is under an obligation to do something. That's a legal question. What that something might be is also a legal question. And the determination of whether this is purposeful or by accident has legal implications. And so we start to see the radiating of these questions outside. That's one sort of reverberation, I think, is worth putting in the environment. The second reverberation, and I know Gabrielle has thought a lot about questions like this, has to do with the presence, the centrality, the influence of an institution like the International Criminal Court. The International Criminal Court, which finds itself by chance with a newly appointed prosecutor, Karim Khan, has made several field visits himself to Ukraine. The International Criminal Court has seen quite a bit of attention in and around Ukraine and around Russia's war in Ukraine. And so with that, to what extent this moment, the legal front of this moment, provides a platform for thinking about international criminal justice, which is not the only way to think about law, but international criminal justice in relation to the institution that has had struggles in finding a footing at times in other locations and places and situations. And so we're seeing quite a bit of funding flowing to the ICC, quite a bit of attention. We're seeing some countries providing funding to Ukraine in order to do investigations of war crimes that wouldn't disturb the evidence for future prosecutions. Right? So we're seeing a sort of a coming together of resources in and around these questions. I think that's part of how one might think about the legal front. And we're seeing a language, maybe ironically, out of the US, which has resisted the influence of the International Criminal Court in other ways, but we find ourselves with a new US president, and a language of, this is our Nuremberg, right? Now, that's an interesting question to think through, and I'm happy to sort of be part of that conversation if we get there, to what extent that changes those roles. The last thing I'll put in the environment around this has to do with an article, an op-ed, that this group has collectively read over email the past few days by Ivan Krastev that was in the New York Times just a few days ago, where Krastev outlined how, in fact, the title of the op-ed I think is actually quite useful. It's called "The War in Ukraine Will End, and that's when we'll see the true tensions in Europe." And it's quite striking, this is on November 8th, quite striking that nowhere in that text does the word law appear. Nowhere in the text does the word court appear. Nowhere in the text does the word crime appear, right? Now, sanctions appear. We could talk about sanctions as a legal way of doing things. But other more direct use of the words law do not appear. And I think that opens a question there about, is the imaginary of the war in Ukraine will end, and that's when we'll see the true tensions in Europe, is that imaginary outside of the legal front? Does the legal front have implications for that imaginary? And how might we think about that? So that's a lot to put out there. But my tendency is to think about the legal front in relation to all these questions: the political front, the economic front, the institutional front. But there are also very direct questions about war crimes, atrocities, maybe crimes against humanity, maybe genocide questions that are at one level more doctrinal, but very pressing and of the moment as well. So we're going to turn to our 5 other panelists. We're going to do this in alphabetical order by first name, because that's how it appears on my screen. And so we're going to turn to Afonso, and on deck will be Gabrielle. Everyone will have as long as they need, frankly. We've discussed maybe 7 to 10 minutes per person, but if you go shorter or longer, that's fine too. Just a point for folks in the audience, those of you who've been here before know this, but if you put in your questions, we will see them in the Q&A box. We may not get to them right away. I'll moderate a Q&A at the end, but if you have questions in the interim, you shouldn't refrain. Put them in, and that might be something that the panelists think about as they think about their own comments in a relatively informal conversation here. So, Afonso, the floor is yours.
So thank you very much, and thank you especially to the University of Toronto to invite me to share my opinions about this conflict. So looking to the legal framework in which this war happens, I think the laws of use of force and also the laws of war tend to be seen as very straightforward, and in somehow it's true. So the first thing that we can say is that the invasion of Russia in Ukraine is a violation, in the most strongest sense of Article 2.4 of the United Nations Charter. So it constitutes an act of aggression, as it has been called for so many leaders of countries, and it legitimized Ukraine to use self-defense. To put this in very broad terms of what is going on. What I think is very interesting is to analyze the arguments that are presented by the Russian Federation for the intervention in Ukraine, so the so-called self-determination right of the Donbas region. So the right of secession, that is the right to a part of a territory to separate from the parent state, is actually not recognized by international law, except in two very specific circumstances where the constitution of the country enshrines that right, or which is not the case because Ukraine is independent since 1991, or when we have, as the Supreme Court of Canada has ruled in one of its cases, when there is severe situations of violations of human rights. So the jurisprudence of the Supreme Court of Canada is very important because they summarize what international law says about the right of self-determination. And it's interesting that Russia has invoked the right of self-determination of these regions when the Russian Federation, in the situation of Kosovo, has rejected adamantly the right of secession of any territory, and even questioned the situations of massive violations of international law. So there is here a change of policy regarding the Russian Federation, but looking to the arguments and as the ICJ has summarized in this assessment that it did asked by the Ukrainian government, it's very clear that the justification presented by the Russian Federation has no grounds in international law. So we have not a situation of severe violations of human rights by the Ukrainian regarding the pro-Russian population, as President Putin likes to call it. It's true that it is registered that there were some problems between the central government of Ukraine and those populations in the Donbas region. There's some measures that were taken by President Zelensky, but if we analyze it from the legal point of view, we never could classify them as violations of human rights regarding a population that feels more attached to Russia. And feeling cultural identity with another country does not even justify an intervention, because we need to talk, we need to clarify what the right of self-determination is. Then we have this massive invasion by Russia. Ukraine, as any other country in the world, was caught by surprise, and we're talking about one of the most sophisticated armies in the world, as the Russian is. And it's true that, it's easy to conclude that Ukraine, without the help of the rest of the world, would be totally defeated and destroyed even more than it is at the moment. So we have these states helping Ukraine, not becoming neutral. We can look for justification under the laws of state responsibility. So the states are aiding another country that is being violated under norms of jus cogens, But it's clear that members of NATO and the rest of the world do not want a direct confrontation with Russia. I think that is a very a tremendous argument that President Putin uses when he threatens the world with nuclear weapons, because it's precisely what the rest of the world is trying to prevent, is a nuclear conflict. So President Putin plays with this card, and is how the situation is at the moment. Of course, we have also, from the legal point of view, severe concerns regarding the support of China and India, and also the direct support of Iran with weapons, namely these kamikaze drones. Why it is so important? Because under the status of state responsibility, no state can aid or support a state that is violating norms of jus cogens, as it is the act of aggression. So aggression is a norm of jus cogens, it cannot be violated, and we cannot go into wars of aggression. So the responsibility of, especially of Iran, when it's aiding with weapons, is a big question mark. Now, I look into the fact that you just mentioned about the missile that hit Polish territory. I think the first reaction was to ask if it was a missile coming from Russia, and that would alarmed immediately not only the Polish government, but also the members of NATO. But I think there was here, we need to understand this under the coldness of law. First, mistakes and malfunctions and errors with weapons happen in every single conflict. And an error or a malfunction or an accident do not justify or do not trigger the Article 2.4, that is for people that are less familiar with the laws of war. So Article 2.4 is the principle of prohibition of use of force among states. So it wouldn't trigger necessarily. It's true that the ICJ, for instance, in the oil platform case, stated that one single target of a naval ship could be trigger the Article 2.4. But here we don't have intentionality. We had to prove that Russia had the intentionality to target another state, which we don't. And actually, at the moment is being discussed if the accident was not provoked by Ukrainian forces. So even if it was a missile coming from Russia, that would not trigger, in my opinion, the right of self-defense of Poland or Article 5 of the NATO treaty. So I think there's a severe alarm regarding that. Now, of course, the most interesting questions, and I think I really enjoyed the email that we shared before this panel with Gabrielle, because she shared some of my pessimism regarding the situation, because the laws of war and the laws of use of force, which are separated branches of international law, are being discarded by Russia, but also some problems by the Ukrainian forces. But at the end of the day, I just think if we do not have the appropriate mechanisms of accountability, and that I will leave to Gabrielle because it's her area of expertise, I think we can have a moment that international law in its entire framework can be questioned by ordinary people. What are we doing with the United Nations Charter? What does it mean that a war of aggression is a violation of a norm of jus cogens and so on? So I think that at the moment, I think that my part dealing with the laws of the use of force and the laws of war is the easy part. The difficult part will be with international criminal law. And I will leave it here just after this big summary and about what is going on. If that is all right.
So it's the privilege of the first speaker in the panel to sort of raise the big questions and to leave it for everybody else, right? So
but never before I regretted to have my name starting with an A. This was the first time, but okay.
But just as we turn to Gabrielle, and partly because Gabrielle and I have had so many conversations, I can maybe divine what might come. I could just summarize a bit of Afonso's points in the abstract. The first, for me at least, as I heard them, is that actions can be violations of jus cogens, by which we mean the fundamental principles of international law, but may still, there's no necessary relationship between that and the capacity to prosecute through the International Criminal Court, for example. And so the crime of aggression in this particular case, which someone may want to speak about, the International Criminal Court finds itself flat-footed in the Russian context around the crime of aggression for various jurisdictional reasons, which does not mean that the act is not a violation of jus cogens, but it might mean that the remedy for it, or the action to be had for it, doesn't lie where one might imagine, right? So that's the first point. The second comes to a real question, which, Afonso, I admit I'd not thought about, which is what the legal implications are for states that engage in abetting and aiding violations of jus cogens, right? That's a really interesting question that people in the audience might be interested in. I think it raises, as you say, questions around China, Iran, and others. And so there's a really interesting question there. The last comes to this Article 5 question. And I think there are sometimes a little bit of knowledge can be dangerous, right? And so people know that Article 5 triggers a NATO conversation around response, and an act against one is an act against all. That doesn't necessarily mean, as a legal matter, that even if it were to be deliberate, doesn't necessarily mean that it needs to provoke a military response. And so the question of what an Article 5 triggering under NATO means may also be something that people may want to take up as a legal matter and as a policy matter. So Afonso, that's great. And I'll just I know that's more abstract than where you were, but I just want to lay that out for the audience as we turn to Gabriel.
Thank you. And thank you, Afonso, for your intervention. And thank you for having me. It's actually really nice to be in a group with such eminent experts on the topic. And as Ron mentioned, and had already guessed, I will talk about the ICC. And I will try to sort of zoom in and zoom out. So I'm zooming in into one legal avenue, one institution, the International Criminal Court, and what it can do and what it's doing now. But I will zoom out to the future to sort of circle back to the op-ed of when the war ends. That's when we will see the real tensions in Europe, because I think that will also reverberate to the ICC, especially if things go ahead as they are currently going. So while the ICC is featuring prominently in the media, as already mentioned, and seems to be one of the most public sort of embodiments of international law currently, I will first give a quick rundown of what has been taking place at the ICC this year, and then I will zero into two interrelated challenges that have been placed at its doorstep, whether it is aware of that or not. So as many of you, probably most of you would know, the ICC intervention in Ukraine started in 2014, so quite a while ago, with the opening of a preliminary examination in April of 2014. Following Ukraine's declaration and Article 12.3 of the Rome Statute, under which it accepted the jurisdiction without becoming a state party, and that's also an important thing to consider for the future. Initially, that was jurisdiction only over the Maidan events, so just several months, and in 2015, this was extended, and this time with no end date. And this has stalled and was widely perceived by Ukrainian civil society. I was also at the court at the time as hugely ineffective, unnecessarily delayed. And in fact, while the OTP concluded the preliminary examination in December 2020, even at that time, no steps to actually open an investigation were taken until the events of February 2022. So the perception of the ICC was quite negative at the time. And after the full-scale invasion, it was a complete watershed moment for the ICC. It picked up at a very brisk pace. The prosecutor didn't even have a moment to actually ask the judges to authorize investigation, because the state stepped in and referred it. By now, I think it's no less than 43 states that have referred the situation to the OTP, and this investigation was opened within the first week of the invasion. And since then, we know that many states have given financial contributions, as Ron mentioned, also technical expertise, seconding personnel. It is unprecedented support. Currently, the Ukraine investigations team is the largest team ever at the ICC, so the resources, even internally, are being pulled towards Ukraine and sort of to quick response teams. It has also requested budgetary approval for a field office, which would be the first one in an ongoing conflict for the ICC. And in a few weeks, we have the Assembly of State Parties meeting in The Hague, where they will decide whether to approve the budget or not. And thus, as mentioned, this broad level of support, this revitalizing of the ICC has been unprecedented and for many quite unimaginable. As mentioned, the US just 1 year prior sanctioning those affiliated with the ICC, and now has not only tacit, but at times quite overt support for the institution. And similarly, states parties for years calling for net zero growth at budgetary discussions and practically limiting the ability of the Office of the Prosecutor to conduct any of the investigations, to be honest, are happily providing voluntary financial contributions to the court, ostensibly with the aim of fast-tracking the Ukraine investigations, also specifically for that matter, even though that actually is not allowed under the rules of the court. And that is all, of course, very much desirable. The court, having struggled for the past 2 decades, not only with operational, legal, political legitimacy challenges, appears to have been revitalized, risen again in the face of a crisis. But it is precisely the perception and the naming of the armed conflict in Ukraine as an extraordinary crisis or an extraordinary event that raises issues in my head, at least, questions about sustainability and the willingness to structurally support the court and not to do the sort of quick response to crisis. And hence the two interrelated issues to which I come. And the first one is that short-term support limited to response to Ukraine will not translate to structural change. And that would increase the perception and the actual de facto selectivity of international criminal justice, which is already a constant critique towards the court. So in the short term, the mobilization of support has allowed the ICC to react more quickly than ever, to be on the ground where validations are ongoing and to make itself relevant again. We see them in the media, we see the prosecutor being interviewed on all the major channels of the world, in contrast to the usual perception of an institution coming in too late and doing too little, which was the last 2 decades of the ICC taken as a whole. However, if the current support dies down, once Ukraine is not perceived as an extraordinary crisis anymore, so that is the part of where the war is over, and we all know how quickly the patience and the attention runs out, what we get is more of the same as before, a system that is reactive, selective, and constrained by states' interests, and that would be more obvious than ever. And hence, it is of utmost importance that thinking, also legal thinking and policy tools, are currently put in place now to mold support into something more systemic. And this could be done, for example, by a budgetary reform, establishing current needs of investigation into Ukraine as a standard upon which resources into other situations should be judged upon, and not as an exception to the rule, which I think is how it will be framed. So this is sort of an extraordinary investigation, and it cannot be expected that other comparable situations would require the same amount of resources. But it could also be aided by the prosecutor demonstrating a little bit of balance by pursuing other important conflicts that are in his purview with the same dogged determination, if not with the same resources, if that is not within his ability. And I will quickly get to the second issue, which is very much related, and that is something that I see more in the East. So as I mentioned, I'm from Lithuania, and we also have quite some Russian speakers and supporters, and that has always been a natural part of life in Lithuania. But the issue is that current spearheaded focus of the OTP on Ukraine basically feeds the perception that the ICC is a tool of Western hegemony, willing and able to investigate and prosecute only in those situations where the prosecutor's interests align with its donors, and the donors currently are mostly Western. So if one peruses any of the Russian and likely state-controlled social media accounts, every instance of a Western state supporting current ICC investigation into Ukraine is potential fodder for more anti-ICC propaganda, demonstrating its lack of independence or being a tool in the toolbox of Western nations bent on delegitimizing Russia. And while we might agree in this room and in this audience that such extrapolations are quite far-fetched, a more neutral look at the situation might at least partially legitimize this perspective as things stand now. And now, as before, the ICC lives in the world of realpolitik with notable idealistic exceptions by the prior prosecutor, namely Palestine and Afghanistan, which didn't win her any points over the states. And current position of the ICC now is perfectly aligned with the positions of the Western states. And this again leaves two potential solutions, and only one of them is within the hands of the OTP. First is that this perception might improve if non-Western states would come to the support of the ICC as a global court, as vocally and as visibly as do those in the West. And the second, again, goes back to the prosecutor, who must, in whatever the circumstances, be willing to look beyond the burning issue and towards a balanced application of the law to other equally deserving situations. And all of that, just sort of to round it up a little bit, is not to say that what OTP is doing in Ukraine is in any way undeserving, but it is just to say that other situations are equally deserving, and a more balanced approach we see the court following from the promises to the many victims across situation countries. And in the long run, that would aid the same victims in Ukraine as well, because we would have a more balanced and a more supported system, a more legitimate system in the end. So to circle back to Krasov's op-ed of the tensions being revealed in Europe post-war, I think this tension will be visible once everything dies down and the OTP cannot make calls for responding to this major crisis and basically pulling Western support. And we already see some of the support lessening also on the political arena. And I think it's only a matter of time when we'll see what actually happens with the ICC and where the law will sit at the end.
Thanks, Gabrielle, for a superb sort of review of where the ICC sits on this. And I know we're going to turn to Ilona in a second. So let me just very quickly, as a rejoinder to your point about Western states, right, to take the US and France, two places I know well, right? So the French government, Macron in particular, has worried humiliation of Russia right now. That, oh, I think we've just lost Ilona for a second. Monica, you might be on deck if Ilona doesn't come back. This question about humiliation, right, is sort of is an old story in international criminal justice that goes all the way back, of course, to the Nuremberg moment of whether a criminal trial would humiliate individuals and what that might mean. So the French position, even as a Western state, has been fraught on the question of criminal justice. And of course, the US position is being reshaped, as you say, under our feet, right? At a moment where the US was not only resistant, but antagonistic to the International Criminal Court, to now have a new ambassador at large for war crimes, to now have support for the ICC in various ways, to have people discussing Nuremberg moment. Of course, the Nuremberg moment was Nuremberg by and for the United States, as well as other nations united post-war. But of course, US lawyers led that charge. And one wonders here whether it's US lawyers who are, again, sort of feeding the interest in support for the ICC. So all this to say, even within Western states, there are multiple audiences that one thinks about when one thinks about international criminal justice. Ilona, you are back, so Monica is off the hook for a moment, and we will turn to Ilona.
Hello, thank you very much for inviting me, and it's a great pleasure to talk today about the war crimes and about the legal front which Ukraine is working on. So maybe to make a small introduction, I would like to talk about what is legal front is for me. And talking about the war crimes, we usually talk about the responsibility, and maybe for my perception is not the all the aspects which are important. So of course responsibility is the most important one, But still, there are two more elements, in my opinion. First of all, it's about stopping the war crimes from happening. Because staying in Ukraine, I can say that these war crimes are happening just now. Yesterday, we didn't only have the situation in Poland, there was also a terrific shelling of the all Ukrainian territory. And we also understand that Russia will proceed with war crimes. So what we're talking about is not only the situation, an abstract situation from the history, but it's also a problem which we must face as lawyers. And as it was already mentioned today, we see the violation of Ewha Comfort rules, and we also see that the world has no legal instruments to stop it. So even when we have some rulings from the ICJ, I don't know whether we can implement them, for example. The third element for me is also preventing war crimes from happening in the future, because if we do not make any changes in the world order based on the situation in Ukraine, I think that such situations can continue and it will be not very good. So that is why Ukraine is talking about reforms of the world order, even if it could sound a little bit too maybe complicated now, but still it's one of our objections. So to come back to the question of maybe the position of France and some other countries about not humiliating. In my opinion, it's not only the question of Ukraine anymore, and it's not only the question of some political agreements, possible agreements, because it's also the problem of all the international communities, because the obligations which were breached by Russia, they are not obligations for Ukraine. They are obligations erga omnes, so before like the obligations of the whole international community. So what we have now is also the changes in the public policy of the Russian Federation. So when the full-fledged invasion began in February, the Russian authorities usually denied the commission of war crimes, even when Ukraine and some foreign journalists or experts show the evidence of the war crimes. Russia usually told that no, we had done nothing about it and all is propaganda prepared by Ukraine and its allies. But what we see now, the position of Russia has changed very much because when we face all these shellings against the civil infrastructure and energy infrastructure, which are definitely the war crimes, Russia declares that yes, we commit this thing and it's normal for us. And we have even the declarations from the not only from some military people, but from the political leaders of the Russian Federation. So what I mean that if we just don't prosecute the people who have committed the war crimes, we say that everybody could do it in the future. Nothing will happen with you if you are politically, if you have some political weight in the international arena. So I think that every country must be interested in bringing Russia to justice, not only Ukraine. My other point is about stopping these crimes. So what are the usual instruments now? I think it's first of all sanctions, because they bring many harmful effects on the Russian Federation. But what we usually have about what the discussion is usual concerning sanctions is that it is political instrument. It is not legal instrument, and it is up to every country whether to introduce sanctions and whether to adhere to the sanctions which were introduced, for example, by the US or the EU. Or some countries believe that sanctions are political decisions, and even today in the statement of G20, we see that some countries do say that their opinion to sanctions differs. Once again, as we face war crimes in Ukraine and as we face even some elements of genocide, I believe that countries are obliged to implement sanctions, and countries also are obliged to do some actions to stop the Russian Federation from its activities. For example, when we look at the articles on the responsibility of states, it is suggested that if a state breaches jus cogens, then no other state can recognize its actions or its deeds as lawful, and also cannot help with it. So in my opinion, if the country just does nothing and continues usual business with Russian Federation, it's not neutrality, it's helping the aggressor to proceed with its aggression. The same we can see when we talk about some international business, because I'm also working with my colleagues in the one of the organizations which foresees the sanctions and foresees the international business which keeps working in Russia. We see that many companies not only provide some humanitarian help, some just usual business with shops, etc. They help Russia in the military scope. For example, a lot of chips which are found in the Russian missiles are made not in Russia, not in Iran, but in Western countries. And we do understand that a lot of companies proceed with this business. So my legal question is whether these companies can also be at least partly responsible for some war crimes. At the beginning of aggression, it was not so, but now we have the 8 months of aggression, and everybody understands that if you sell these kind of things to Russia, they will end up as a means of war crimes. For me, it's very important that sanctions could be foreseen as a legal part. And maybe the last thing which I would like to focus on is how we could change our approaches to the future. So first of all, as already have been mentioned today, yeah, we could proceed with war crimes in the ICC. I don't want to come back and to talk about whether ICC is effective, but still ICC exists and it's already good. But we have no international institution where we can talk about the crime of aggression committed by the Russian Federation, by the Russian officials. So when Ukraine tries to advocate the idea of the creation of a new tribunal, I know that a lot of lawyers from other countries say that it's a bad idea because it could be some bad things for the ICC, etc. But the truth is that we have no other possibility to bring the Russian leadership to justice for the commission of the crime of aggression. So that is, I'm talking about the reform of all the architecture of the international institutions. And the other thing, I also believe that we should talk about the reform of the UN, because what we see now is that a war criminal works on in the UN. A war criminal can have a veto right in the UN Security Council, and also me as an international lawyer, I believe that there are legal grounds to prove that the Russian Federation is unlawfully represented in the UN Security Council. So it's also one of the issues which we must meet in the future. And without such reforms, maybe really complicated, I think that we couldn't move forward because we'll always come back to the same problem. To sum it up, I just want to say that international law is the thing which makes me really optimistic about our future. Yes, we have a lot of legal problems in the legal front, but also we have a lot of opportunities, and I believe that international law can be more proactive and more prognostic, and that's how we can make it more effective, not only for Ukraine, but all for the international community in general.
Super. Thank you, Ilona. In fact, I want to turn to Monica and Alexander quickly, but I take from this the importance, I mean, in my words, law isn't only where you think to look for it, is how I hear it, right? And so the question of sanctions, which as we've all discussed, are often conceived of as political. People engage in sanctions as a political matter are, of course, themselves legal questions. And with that, the kind of the supply chain that you think about, or that you discussed about the pieces of weapons, right? To think about complicity along the supply chain and collaboration along the supply chain. I think, again, law isn't only where we think to look for it. It isn't only, for example, in use Kogan's or in the ICC or somewhere else. The other piece that, to me, Ilona, your comments push us toward realizing is that the Security Council, as itself the kind of I'm not sure what to call it, the switch master, the sort of the guardian of some other legal pieces, including the International Criminal Court, including others, is itself a legal entity in that sense. And to think about the Security Council not only as a political space, but as a legal space that has influence over other legal institutions and the capacity to implement other legal institutions as requiring reform, to me, is again to make us realize the legal question is bigger than the sort of the narrow-headed sort of egghead lawyer question of what is the doctrinal question. So thank you for that, Ilona. Monica?
Great. Thank you so much. Thanks to our colleagues at the University of Toronto and for the opportunity, speaking on behalf of this Center for International and Comparative Law at St. Louis University. Thanks for the opportunity to co-sponsor this discussion. I'm also really grateful to the commenters who have come before me and for my friend who is coming after me, because I think that you've given me a lot to think about, but also I see your comments resonating with some of the things I've been thinking about. And Ilona, to build on your last point about the architecture of the UN Security Council and the fact that the Russian Federation, as one of the 5 permanent members of the UN Security Council, has a veto power and can veto, for example, sending in peacekeepers to Ukraine. I'm going to contradict myself. I actually agree with your point that the Russian Federation, that there is room to question why and how the Russian Federation acceded to the position of the Soviet government in these matters. But if I may, I'm going to contradict myself on that point. And I'm going to look to, in my comments, I want to look at past, future, and present. And the past, I want to look at Soviet jurisprudence to try to understand the legal doctrines or the legal thinking that the Soviet Union held in the past that should be influencing or informing decisions in Moscow today. So how does the Soviet legacy play in? That's something that I'm trying to look into now, and as a very recent point of research that I've taken up. And I'm looking at, in 1943, there's a statement on atrocities that was agreed to by the US, the USSR, the UK, and France. These 4 governments agreed that all atrocities committed against civilians during World War II, so 1943, in the middle of World War II, will be tried and punished at the end of the war. And where individuals and incidents can be identified, then they should be tried on the spot where that thing happened, in the country, in the jurisdiction where that crime was committed. If there is a general or if there's a crime that's of such a general nature that there's not one spot where it occurred, for example, genocide, then the 4 governments bound themselves that those crimes would also be tried by a process that would be managed by the Allied governments after the end of the war. And the reasoning for this, including the reasoning by the Soviet government, especially because of the Nazi crimes that had been committed on the territories of Ukraine and Russia and the other republics of the Soviet Union, the reasoning was exactly what you said, Ilona, to the threat of future accountability. The hope was that the threat of future accountability, if you make that a promise in 1943, then maybe fewer war crimes will be committed between that point and the end of the war, as a point of deterrence during the conduct of the war. So I think it's super important to focus on, from our past experience, how the promise of accountability may influence individual soldiers and commanders on the ground in the course of the war. In looking at this statement on atrocities, my attention was brought to Major General Nikitchenko, who was one of the Soviet jurists. He helped draft the London Charter, and I'm contradicting you here, Ron. The Soviet jurisprudence is very proud of its actions in establishing the Nuremberg trials. And they're very proud in setting up the rules of the road in the London Charter, and also on the role played by the Soviet judge Nikitchenko. As the chief judge, General Nikitchenko insisted on the crime against peace, which was the aggressive war, but also on war crimes, crimes against civilians, for example. He drafted the only dissent. The Soviet judge drafted the only dissent at Nuremberg, dissenting against the very few acquittals that the Nuremberg Tribunal had reached. And so Soviet jurisprudence has a foundational role in establishing an accountability for crimes committed during war. And that is something that I want to know, and I'm trying to research, but I want to know, what is Russian jurisprudence now, and how are they treating their own proud history in that, or a history of which they have been proud historically. Also, to speak about the past, the United States has made a decision in the past not to be a member of the International Criminal Court. And I will repeat the Americans' lament that this robs us. It ties our hands as lawyers, as citizens, as concerned people of the citizens of the world, also as a government. It ties our hands in how we can be active and what role the United States could play through law or in law. This is a plea to any of my fellow lawyers in the United States who may be listening to this panel. We are not a member of the International Criminal Court. That is a shame for us, and it denies us a position of leadership, and it robs us all of some tools. So this is something that we need to work on. The only silver lining that I have seen in the United States non-membership has come up for me today in hearing Gabrielle's comments and thinking, this is, at least the International Criminal Court cannot be accused of being a tool of the United States. It may be a tool of the West, or of Western hegemony, but not of the United States, because we aren't a member and we have very little to do with it. It's practically hard to teach it in our law schools, and our legal community is very unfamiliar with it, and it is not a tool that our government looks to. So unfortunately, it's not a tool of us. I wish it was, but it's not. Finally, I want to talk, that's thinking about the past, thinking about the future. And this is bringing me to a question that I have from my friend Alexander Merezhko, who's the member of parliament in Ukraine with us today. Ukraine has 7 EU recommendations to fulfill regarding its candidacy for EU membership, for membership in the European Union. Last spring, President Zelensky hoped to get all of those 7 done by fall. Now the Ukrainian government is saying they're hoping by the end of the year. It's a lot to do. The one that Ukraine seems to have made the least progress on of these 7 recommendations is on judicial and court reform. Constitutional Court, the Ethics Council for the High Court of Justice, which is the body that vets potential judges, as I understand. And I'm curious just to hear from Professor Merezhko what the progress is on judicial reform in Ukraine, and thinking about law and thinking about the future, if the future of Ukraine is towards Europe. A key part of this is domestic judicial reform and how law is institutionalized in Ukraine. And I'm curious on how that's going from his perspective. So that's what my question about the future. And then to think about the present, I'm really grateful for my colleague, Professor Afonso, and for you, Alona, for your pointing to the present state of the law, the present shelling of civilian infrastructure, the present violations, the present perpetrations, thinking about the present. From my understanding, and I wear two hats, I'm a legal academic and I also am an anthropologist, and speaking anthropologically from the sense that I can get from all the sources that I can gather remotely from Ukraine, it seems to me that Ukrainians have very high expectations of law right now. There are rituals of law, there are rituals of fact gathering, there are rituals of probity, reason, weighing evidence, and airing grievances, of receiving judgments, of having one's story heard, and of repair or remedy. And my question for all of us, some of the satisfaction in law comes from legal rituals, but some of the satisfaction in law comes from the conclusion of the rituals. And my question for all of us is the expectations that Ukrainians have of law, both international law and their own domestic law, is extremely high right now. And the sense of justice and the sense of having been done injustice is very strong. My question for all of us is, can law deliver on those expectations? Thank you.
Sure. Well, thank you, Monica. Alexander, I'm about to turn to you, but just to my own sort of insinuating myself into Monica's comments. To me, with Ilona, it was, law isn't only where you think of it. I heard Monica's comments as suggesting that law is both a past narrative and a moment for reinvention. Right. And it has a past narrative in its techniques and its practices, in the legacy of Nuremberg, and who wears the mantle, who claims the mantle, who disowns the mantle, when do they do so, right? Whether that's within the Russian judicial space, whether that's in the American legal field, right? Contestations over that. But there's also sort of a doctrinal piece to that legacy. Sexual violence is an important example, frankly. Sexual violence in the more recent jurisprudence, no longer so recent, of the past 2 decades, can be nested as a war crime, as a crime against humanity, or as genocidal. And so that is a legacy of the current moment that is marshallable. And yet, as Monica, as you say, it's also an important question and moment for reinvention, to think about the capacity of judicial institutions domestically, to think about willingness to join international institutions like the US doing so with the ICC, for example, right? So the reinvention moment is, I guess all I'm saying really is what you've said, which is that the past and the future coincide in the present. But to think about law as holding both of those, I think is a really important insight. So thank you, Monica. Alexander.
Good evening, dear colleagues. Thank you for inviting me, and it's very interesting discussion. I'll start with a question which was asked by Monica regarding judicial reform, because in Ukraine, judicial reform is considered to be one of the most crucial and maybe even key reform. What should be done, it's more question not to my committee, but to the Committee of Legal Policy, of which I was a member 2 years ago. But I understand that at least following things should be done in terms of successful accomplishment of the judicial reform. First of all, we need to change the so-called Вища Рада Правосуддя, the highest council of justice. This is one of the requirements of our EU partners. And the second is about new procedure for the selection of the judges or justices of the Constitutional Court of Ukraine. So, and I believe that the Committee on Legal Policy is working on this, and we will prepare and we will try to implement as soon as possible all the necessary legislation. So we continue legal reform or judicial reform, but at the same time, to me, judicial reform is more, I'm as a representative of Sociological School of Law, I believe that this is more about legal consciousness, which is more difficult thing to do, but it's a separate story. I would like to start, we raised a very interesting issue, by the way, regarding the right to self-determination. This right to self-determination, its analysis is indicative and is very interesting because it helps to shed the light on how Russia understands international law. And I will start with a quote from the materials of the Nuremberg trial. They quote the program party of the Nazi Party. And point one of this program of the Nazi Party is following. We demand the unification of all Germans in the Greater Germany on the basis of the right of self-determination of peoples. So to me, this is exactly what Russia is trying to do right now, using the right to self-determination. And it's interesting to see how inconsistently it understands and interprets the rights to self-determination. For example, the right to self-determination for people or nations living in the territory of Russia itself is prohibited. You can go to prison for raising this issue. It's a crime. But when you send your troops abroad, when you hold a referendum under the gun barrel, under the control of occupying authorities, it's correct. It's right self-determination for Russia. And you can see in this example the whole attitude to international law to Russia. But I would like to say something different. First of all, I'm deeply convinced that right now, the fate of, not only the fate of international law, the fate of all humankind is being decided in Ukraine. Why? Because we have to answer the crucial question. Upon the answer depends our future of the whole mankind. What is to be done with the perpetrator and with the crime? And there are three possible options. The first one, the perpetrator should be awarded for his crimes. For example, Russia should receive what it wants, sphere of influence or territorial gains and so on. If we choose this option, the whole evolution or de-evolution of mankind will go in one direction. You understand in which. Second option, the perpetrator should go unpunished. It's also another option, which is very risky for the development and future of the mankind. And finally, the right option to me is that the perpetrator, the aggressor, should be punished. In this case, if we follow this pathway, if we follow this choice, we have a chance to develop, I mean, for the mankind. And I would like also to add a few words regarding the recent developments on the legal front. What has happened recently, which deserves our attention? First of all, and this development is important, several countries, Baltic states, and yesterday it was the Czech Republic, have recognized Russia as the terrorist regime. Before the resolution of the Parliamentary Assembly of the Council of Europe was adopted, which states that Russia is the terrorist regime. It's extremely important development because we understand how we should treat right now Russia. Russia stops being a state. It's a terrorist regime, and it should be treated correspondingly. For example, the terrorist regime should not be member of G20, or the terrorist regime cannot be a member state of the United Nations organization. By the way, another development, we continue in Ukraine to raise the issue that Russia has absolutely no legal grounds to be the member of the UN, of the Security Council, because Russia had usurped, had taken illegally, in violation of the UN Charter, the place of the Soviet Union on the Security Council. It was political, it was not legal decision. And we should not expel, but I would use more correct legal term, not to recognize Russia as a member of the UN. And we should be very outspoken and say loudly about this. Russia has no right. We shouldn't recognize it. And besides, as I said, it's the terrorist regime. Second development, the most recently adopted resolution of the General Assembly on the international legal mechanisms of reparations. It's important because it gives a signal, it gives impetus to all the civilized, by civilized I mean rule of law states, by all civilized and democratic countries to start freezing Russian assets and Russian property and giving them to the victim of the aggression. It's important development. And I hope that we'll follow the example of Canada, by the way. Canada is a trend setter, so to speak. You have adopted excellent law, allowing to freeze and to confiscate Russian property. It's a good example for all world community. Another development, recognition of recognition of genocide committed by Russia against the Ukrainian nation. Several countries, their parliaments have already recognized Russian crimes against Ukrainian people as a genocide. It's extremely important development because, as you know, genocide is a violation of norms erga omnes. It's a crime against not only against Ukrainian people or against Ukraine. It's a crime against each country. And when we have genocide, each country is obliged to react to this. It's another important development. I think that I have mentioned almost everything what I was going to mention. And one final point, you know, when we're talking about crimes committed by Russia, we usually distinguish classic crimes like war crimes, crimes against humanity, war of aggression, and genocide. And Russia commits all these crimes. But I would also distinguish another crime, which is equally important to me. I call it criminal brainwashing. This is how Russian propaganda works, because if we take the materials and the judgment of the Nuremberg Tribunal, we can find decision regarding Julius Streicher, who was the leading Nazi propagandist. And in its judgment, the Nuremberg Tribunal had found him guilty of such a crime as a crime against humanity. But I would distinguish this crime because Russian propaganda has shown how dangerous, how genocidal can be propaganda, because it incites genocide. And I would also distinguish it as a separate crime. Thank you.
Thank you, Alexander. I know that I've been tending to give a bit of comment just after each person. I'll just say that the Streicher case, of course, finds itself as well in the International Criminal Tribunal for Rwanda as part of the media trial there. And so the question of the relationship of actors who, and Ilona spoke to this a little bit, who may have a symbiotic relationship with the state, sometimes within the state, sometimes outside the state, sometimes private, sometimes public, but who control the narrative, or at least have influence over the narrative, as Alexander suggests, isn't outside of the scope of the legal field. I'll turn to Afonso because I think Afonso has some comments maybe to wrap around with Alexander's, and then we'll also keep an eye on the Q&A. There's some questions there. I know, Afonso, there's a question for you, so perhaps you want to take that at the same time, and then we'll turn to some others.
Yes, thank you. I will address the question, but I wanted just to make some comments, and I'm sorry for my first intervention. I think I was too nervous for being the first one, but I think, you know, I think that what is happening in Ukraine and the intervention of Russia in Ukraine, you know, if you would give that case to any student of public international law, you would get an A+, because it's too easy, in the sense it's the violation of everything that is sacred in international law. However, I think, and I was teaching Ukrainian journalists and promoted by an organization in Kiev, and I had some difficulties sometimes to explain when we go to the level of detail, and I think Gabrielle was raising this issue, the problems of evidence, and actually we need also to recognize that things are not also so clear, black and white, in terms of, for instance, in terms of war crimes performed by Ukrainian troops on the ground. I think sometimes we get overexcited how you analyzing these questions, but I'm not, as please understand me well, I'm not saying that Russia has any grounds for the intervention. I'm saying when we start looking to the details, what happens on the battlefield, we won't only find violations of the laws of war by Russian troops. We will find them as well by Ukrainian troops, and this gets the problem more complicated. One thing that I was expecting for Gabrielle, which I loved your intervention, by the way, is what do you think about this special court for aggression that some states and especially academics are raising? This if a new court would actually solve problems that the ICC already has, let alone, for instance, problems of immunity regarding. But I wanted to talk about one question that Monica raised, and then to answer the question that I've received from the audience. I think there is some changes on the constitutional decisions of some changes at the level of the jurisprudence of the Russian Constitutional Court. And if I remember well, Timothy Snyder, in one of his books, analyzes precisely that, and the influence from Ivan Ilyin in the way that President Putin is conducting the external policy of Russia, and how that is affecting also the constitutional decisions of Russia at the moment. Just for a start, Ivan Ilyin is invoked in every decision that the Constitutional Court has, and that tells a lot about how Russia is performing in this war. Regarding a question, a very provocative question that I had from one members of the audience, I think it's Antoine, when I referred that the reasons that Russia gives to intervene in Ukraine is the so-called right of self-determination that has no grounds whatsoever in Ukraine. And I referred that there is also violations committed of human rights by President Zelensky before the intervention. Well, and the person asked very kindly, where do I find support for those remarks? So first, it's well known by all news that in 2021, President Zelensky closed 2 pro-Russian TV stations. It's under his authority, it is. But just to give you a situation. Then if you go to the US State Department website and the report that was made by the State Department of the United States in 2021, you can read at a certain moment that civilian authorities and members of the government, there are credible reports that members of the security forces committed some abuse. Significant human rights issues included credible reports of unlawful arbitrary killing, including extrajudicial killings by the government or its agents, torture and cases of cruel, inhumane, or degrading treatment or punishment of detainees. So this is before the intervention, is a report of the human rights situation in Ukraine before the intervention. So I'm not supporting in any how, I need to underline this, the intervention by Russia, but there were situations of concern happening in Ukraine. Does that justify an intervention? Of course not. Otherwise, every single country would have an intervention by its neighbors. But I'm just saying that there is reasons of concern. And so that was what I was saying, that there were actually situations of violations of human rights reported by any state in the situation on the region of Donbass committed by Ukrainian authorities. That is what I was trying to say. And with this, I conclude what I wanted to say. Thank you.
Thank you, Alfonso. Monica, over to you. And then just right after Monica, just to give a sense of where we're heading, I'll turn to Gabrielle for a question for her, and then Ilona, a question for you that you can see as well in the Q&A. And then if there's time, I'll wrap up with the last 2 questions. And if not, I know some people here on this panel have flights to make today. So Monica, over to you, then Gabrielle, then Ilona.
Great. So just a quick note on Alfonso's last point. I have not read the 2021 State Department Human Rights on Ukraine, but I wrote the 1996 State Department Human Rights on Ukraine, and I would want to look very closely at the particular incidents, were these incidents of extrajudicial killing or torture or mistreatment of detainees, which I have no doubt that there are credible reports that happened before the invasion started. Were those against people on the basis of ethnicity or perceived identity with Russia or Russian language, or was this an ongoing problem that needs to happen with prison reform and prison treatment? So I would want to read the fine print on those incidents very carefully, because I myself reported such incidents in 1996, and I could report them in the United States today, that there's incidents of prison mistreatment. It may or may not be indicative in the United States that we are or are not committing acts of discrimination or genocide. I don't think genocide, but discrimination. But I'd want to read the fine print on that. That's all I wanted to say.
Gabrielle, there's a question for you about complementarity, and I think there's a question that, that question raises questions of competing institutions in international justice generally. So maybe take it both specifically and generally.
Yes, so I will try to also address Afonso's question issue with the tribunal of aggression. So complementarity is of course an issue, and it is not that the ICC did not think about it. So there is an agreement, a memorandum of understanding between the Ukrainian General Prosecutor's Office and the ICC. However, it is entirely unclear, and that is also something that we discussed in The Hague in the sort of legal circles, of how will the defendants be divided. So who will get to prosecute whom, and in case any competition would arise, then Ukraine, of course, would have the primary jurisdiction, and the ICC could not demand to investigate or prosecute those individuals. Publicly, there's always statements that there's a very close cooperation between the ICC prosecutor and the Ukraine's prosecutor. However, of course, as time goes ahead and perhaps ICC has certain targets that, for instance, Ukraine might want to keep as prisoners of war for potential prison exchanges, then issues might arise. But legally, this is a sort of a declaration by Ukraine that they will be unwilling or unable to prosecute at least some individuals, a sort of a preemptive statement. But the issue of competition, and that does arise when we think of the tribunal for aggression in any form that it might take place, is one of resources, attention, and defendants as well. So, of course, we have the norms of not being prosecuted for the same conduct in two different jurisdictions. And it might be, for instance, that the same person would be indicted for the same acts of aggression as a crime of aggression, and then as a crime of war. So at the ICC and at the tribunal, and these issues might arise. Current proposals do outline cooperation and sort of written in articles for cooperation between the ICC and the special tribunal. However, I do not know whether that would work out. And in general, in my view, for this special tribunal on aggression, I do think it is, of course, for Ukrainians primarily to decide whether they want such an institution, and it seems like they would, and Europe generally would want that. But I do not see the rush. There have already been, I think, 4 proposals, 2 with full statutes, proposed statutes for this tribunal. It will not, unlike the 1943 agreement, deter Putin. This already happened. The aggression has already been committed and is continually committed. So I do not think that sort of rushing into thinking what kind of institution it would be and already going to the extent of making proposals currently is a productive avenue. I think focusing on what can be done and sort of keeping it on a back burner, and everybody is aware that there are options for the crime of aggression as well, I think would be at this time a little bit more prudent and probably more effective once the time actually comes and we see who the individuals at the top level would be. And just one more minute, because Lithuania actually started a pre-trial investigation for a crime of aggression of Russian Constitutional Court judges. I don't know if everybody has heard of that. Ilona has heard, which is a very creative use of the law. So they interpreted Constitutional Court signing the annexation agreements of the Zaporizhzhia, Donetsk, Luhansk as an act of aggression. And the judges, since their approval is necessary and mandatory under Russian constitutional law to actually approve any annexation as members of the highest level of the state apparatus. So we'll see where that is going, but there are creative avenues of invoking crime of aggression domestically as well.
Super. And just before we turn to Ilona, just some folks in the audience might not know. So the principle of complementarity that I think the question, as well as Gabrielle began by answering, has to do with the relationship between the International Criminal Court and domestic states. The International Criminal Court finds itself without jurisdiction to prosecute unless the state concerned, is unwilling or unable to do so. And so what one finds in these moments are competition, relationships and competitions between international actors like the International Criminal Court and domestic legal jurisdictions, in this case, Ukraine. And then Gabrielle has inserted the other point here, which is competing international actors or competing by sort of special tribunal to deal with aggression, perhaps at the international level, and what would be the relationship between that and the ICC. So the complications here are multiple and nested in different ways. Ilona, there's a question for you about sanctions, I believe, so over to you.
Talking about the question, I think that there is no easy answer just now, but whether we can bring to justice the companies which still provide Russia with some military things. But my answer is yes. First of all, even the Rome Statute provides that when a person gives means for the commission of the war crimes to the criminal, this person can also be liable. Of course, it will be very hard for us to prove the intention, but I think that it's worth trying. Because as I have mentioned during my first intervention, companies and international business very well understands what they are doing just now. So it's not the first days and the first weeks of aggression, and they still cooperate with Russia with some intent, and it's not business as usual. The other question for me is, I like very much Rosalind Higgins, who was the head of the ICJ, and she believed that international law is not a set of rules, it's also the process. So I think that all of us are creating the international law of the future, and that is why we shall try to do our best to resettle the things and to change the rules. And maybe this also my answer to the question of Monica about whether law can bring the feeling of justice back to Ukrainians. I believe that maybe yes, maybe not fully, but what law can do, the law can make our future more just and to help the future generations to live in more just world. And that's what Ukraine is trying to do, even with all our ideas about new institutions, maybe new rules, maybe new approaches. It's not only about Ukrainians, it's more about the future generations and the world we are trying to build. And also just maybe coming back to some practical thing, sometimes it's not only about the legal responsibility, and the question which I'm answering is a good example. Because when we talk about the responsibility for breaching the sanctions in the US, the criminal procedures is not the worst thing. The worst thing is secondary sanctions, which work very good in the US. And it's very good that the EU has changed its approach to secondary sanctions, because every legal entity understands that when you fall under the secondary sanctions of the US, well, it's worse than the criminal legal responsibility. So maybe if we cannot find some legal answers to the questions, still we can find some practical answers which are no less effective.
Wow. So at 1:27 on the panel that ends at 1:30, we find ourselves with the question of law, the question of justice, and the question of practicality, which three things that do not always coincide. But and I think Ilona is right to the mark when she presents these as how can we make these combine or coordinate or converge rather than see all three as constantly in tension with each other. So Ilona, thank you for that. I know there are many questions on the Q&A that we will not be able to get to. I'll only, as a one-liner, because I promised it, say that the US position around the International Criminal Court, Monica could do this as well as I could, has been a political decision not to sign on to the court. The view there has been multiple. Sometimes it's been just a US exceptionalism argument. Sometimes it's been US exceptionalism plus, in the sense of arguing that American troops often go off and do things abroad to enhance, in the American view, peace of the world, and that this would expose their troops on other terrains to an international court, and that would constrain the US ability to act abroad, or US willingness to act abroad. And the last has been a kind of fear, let's call it that, of what the Americans have called a Dr. Strangelove prosecutor, who would return and seek to take down or to prosecute the US because of its power. And then, as Gabrielle has discussed, in reality, that's not the case, because, of course, the US could always have its own prosecution of individuals, and that would preclude the International Criminal Court. But that's been in the air. So that's a one-liner on what Monica could give a whole lecture on, I'm sure, but hopefully it at least gives people some sense of the US historical resistance to joining the ICC and the complicated relationship it has had, though often providing assistance, intelligence and otherwise, to the ICC through other channels. So it's 1:30 on the dot. So I think we're compelled to stop here, as hard as that is. I want to thank Ilona in particular for ending us on, I think, a really sort of thought-provoking and important next step, and maybe for a third panel in this series, to think about law, justice, and practicality as three themes that maybe we can all think about. But I also want to thank everybody else in this panel and everyone in the audience for really sort of, I think, engaged, what I like, informal and conversational hour and a half about the biggest legal questions of our time, frankly. So thank you for everyone for doing this.